Welcome to Money Secrets with Bill and Mike.
I'm Bill Alexander.
And I'm Mike Tove. And so, Bill, I recently went through a situation with some family members where they passed, and we had to go through probate.
Well, Mike, as you know, probate is where a lot of money is involved in terms of how to deal with probate. And so this morning, I think it's a great topic to talk a little bit about probate and trust administration and some of the things that families can do to save money because it's so important to them, and also make sure that it's done correctly.
Right, well that too, because I run into a lot of folks who have misconceptions about that.
Yeah, yeah, it's true in my law office as well.
So we'll be right back and we'll talk more about probate. And we're back. So you know what? Why don't we start with what probate is?
Good question, and that's really important because probate isn't what a lot of folks think it is. It's really simply you're presenting a paper writing in North Carolina to the clerk of Superior Court. Or in other states it would be to whoever administers estates. So probate is where the clerk determines if that piece of paper is a valid will and probates it. So what a lot of folks call probate, they're really talking about estate administration in terms of the process of putting all of the information together and the rules of the road in terms of administering the estate. But the probate itself is simply a matter of presenting a piece of paper to the court official to determine if that piece of paper is a last will and testament. Now, in North Carolina and every other state that I'm aware of has what's called self-proving wills. And so if your will has at least 2 witnesses and a notary block where the notary has notarized not only the testator's signature but the signatures of the witnesses, that's called a self-proving will. And so typically when you present that to the clerk of Superior Court, then it is received as the last will and testament. But I have to tell you that there are some wills still out there that have no notary block on them, and it has 2 or 3 signatures. And while those are still valid potentially as wills, they're very hard to probate because the witnesses have to be found and go to the clerk of Superior Court and say, yes, I witnessed that, that's my signature, and that's the signature of the other witness, and that's the signature of the testator. We see those wills from time to time, but I've been practicing law for 40 years, a little over that actually, and it was just a few years after I started practicing law that the self-proving statute was passed. So now it's a matter of most wills are going to pass muster when they're presented. The only question is, does someone have one that was actually dated after the one that was presented? Because they only want the last will. That's why they call it the last will and testament.
One of the things that I run into, and correct me if you disagree, people will come to me and they will say things like, well, I have a will, so it should be easy, and there's no question because whatever is in the will is what it's going to be. And I say, well, except for one thing, is that when that will gets witnessed, the witnesses don't certify that every word in the will was correct and accurate, right?
Well, that's part of it, but the witnesses are simply witnessing that the testator has signed the will, and
so
they're all together at the same time.
So a person could theoretically write anything they wanted into a will. Just because they say it doesn't make it so. So I've always assumed that the court has to determine, first of all, are the assets you claiming are yours really yours, or were there anybody else that had title to it? Are the parties appearing before the court claiming to be rightful beneficiaries, are they really beneficiaries? And are there any unnamed beneficiaries that have rights?
Well, that's all true, and that's all part of the clerk's job or the judicial official in other states that administers the estate. That's all their job, to make those determinations. And just because, now obviously it's important for folks to protect the original document because it's the original document that is presented to the clerk of court, not a photocopy of that document. So if you lose your original, that can create havoc as to whether or not you really have a will, whether or not it was destroyed because the testator didn't want it anymore, so they ripped it up and therefore it doesn't exist and the only thing that's left is a photocopy. Or if you can prove that it was not destroyed, there is a process in North Carolina. I'm not sure that there's a process in other states if you don't have the original document. Another problem with probating a will is sometimes people think they can make a minor change to it by crossing something out and writing something in on the paper, and that's okay. Well, typically by doing that, you've just voided your will.
Wow.
And so it's really important that your original will be a clean document, no marks on it, no scratch outs, those kinds of things. But the bottom line is, if you have a will, you have probate and you have estate administration. Now what's funny is sometimes people say, well, we don't have a will, so we must not have probate. Well, they don't have probate, but they still have estate administration, and truthfully everyone should have a will, even though about half of us don't, because if you don't prepare your own will, the state has a will for you. They have a distribution scheme, and oftentimes the state's distribution scheme is not what people think it is. Oftentimes people think, well, if we've been married or if I'm married, my spouse will get everything. And that is just not true in just about every state. Normally the state's plan has a sharing arrangement among your spouse and your children. And every state's plan, or what's called intestacy, is a little bit different. It's not necessarily the same from one state to another. So it's really important for people to understand. And of course, whether you have problems with the will depends on the quality of the drafting of the will. So the very worst wills that you typically would have is somebody who tries to create their own will. Obviously, the quality of the attorney drafting the will makes a big difference in terms of whether that will fly through probate, if you will, and is easy to administer. Because the challenge for a good attorney is not just to do what the person wants in their will, but also to look at alternative issues that can arise. What if this person dies? Who do you want the property to go to then? So those are the kind of things that a good attorney will have always taken care of in a will.
Well, I have a few questions, but we'll be right back and cover them. Welcome back. So we're sitting here talking about probate and some of the issues of it. And I had a question before the break, and it's because you hear people say, well, you really should avoid probate. So what's the problem with probate?
Well, for some families, probate is actually very good. And for many married couples, probate is very simple. Actually, I shouldn't use the word probate. I should use the word estate administration. And that's the process that a family goes through to take one's property, the decedent's property, and distribute it to the folks who should have it. Obviously, when you go through the court process, it's very public. Other folks who are not part of your family can go research what you have and who it's distributed to. And there are, quite frankly, there are folks who do that. They want to find out about those so they can market to you or whatever. So,
well, can't anybody who claims to have a legitimate right file a petition and contest a probate proceeding?
Well, absolutely. There are, one of the disadvantages of a will is the fact that an unhappy relative, typically it would be a child who doesn't get their, quote, share, they're not happy with it. In North Carolina, a child is not an automatic beneficiary. In other words, truthfully, you don't have to leave a nickel to your children if you don't want to. Now, the spouse is the only person in North Carolina that is entitled to receive a share of your property, whether you have a will or not. But your children are not, so if you wanted to leave a child out or all your children out for one reason or another, in North Carolina you can do that. Now, that is not necessarily true in every state, but it is clearly the law in North Carolina. But obviously a child that's left out or doesn't get the same share could potentially contest your will, saying that that's not what my dad intended, or my mom was unduly influenced by my sister, those kind, or my dad was totally loopy when he signed that document. It's not a valid document. Obviously, when a document, a last will and testament, is signed in a lawyer's office, it has far more credibility because the attorney is assessing the ability, the person's desires, also assessing that they're not unduly influenced, and so typically a document that's signed in a lawyer's office has already gone through a level of scrutiny, and so now that's not to say that it can't be challenged. And another disadvantage, particularly in North Carolina, you have to understand that the laws differ from state to state, is that a person who challenges the validity of a will, their legal fees are actually paid out of the estate. And so that's literally where, I have an image of a cow in my office where one family member's pulling on or one farmer's pulling on the tail and one's pulling on the horns, and the lawyers are milking the cow underneath. But the bottom line is that with an estate, the lawyers are paid out of the estate, both lawyers, which is very different. And that's one of the biggest difference between using a trust, because if you challenge a trust, the person who's contesting it must pay their own lawyer fees. It doesn't come out of the trust. So it's far more difficult and far more expensive to challenge, for the person who is challenging it or contesting it, it's far more expensive to them personally than if it's a will-based planning document.
Well, trusts also, don't they have the advantage of being private?
Oh yeah.
So when somebody dies, you see it in the newspaper, the obituary and all of this, and it's kind of like a clarion call to anyone. I heard a story of a vinyl siding company that had filed a claim against a decedent, saying that decedent had contracted them for some vinyl siding and they never paid. Mm-hmm. And that they were filing a claim in probate court to get paid, and it turns out it was a brick house.
Ah, that's interesting. Well, obviously that was a scam.
Yes.
And it's the executor or personal representative's job to determine whether a claim is valid, and if it's not valid, it's their job to deny the claim, right, which should have been done in that case effectively.
It was, but the key here is that, how many times do you have somebody who the decedent lives in North Carolina and their kids have all moved to California or someplace else, and now they have to come back or whatever, they hire somebody out.
I understand, and that's oftentimes where family members will hire attorneys or CPAs to administer the estate and help make determinations as to whether a claim is a valid claim or not. There are scams out there, yep, but that typically is not a problem for most families. Well, one advantage to trust-based planning is, you just said it is private. It's harder to challenge. You typically can have a much more sophisticated plan in a trust than you can in a will. And it's much less expensive to administer if it's done right. And so there are some issues with trusts that are not perfect, and not every family needs a trust. There are lots of families that can get by without a trust, and it's still inexpensive. Although with a probate and trust administration, you have court expenses that you do not have with a trust administration. And court expenses in North Carolina are capped at $6,000, but most trusts can be done for far less than $6,000. So it's, it's the old Midas commercial. You can pay more now
pay
and
me
a
later.
whole lot less later,
Right.
or you can pay less for a will now and pay more later with court costs and higher administration fees.
Well, let's take a little break and come back because I want to spend a little bit of time talking about trust planning so we can contrast the two. So stay tuned. We'll be right back. Hey, welcome back. So right before the break, we've been talking about probate, and we started talking about trust planning as an alternative, I guess, to probate, to a will. So, other than privacy, trusts have more control, right?
Well, no question about that. But before we get that, let me leave it with this. Most people rarely do this, and this is a money secret that people really should do. Whenever you, particularly as you get older, if you're reviewing your documents, you have an attorney, or you're doing a trust plan, that's a really good time to talk to your lawyer about what they charge when you die. And you can negotiate your fees at that time. Not just, the court costs are always going to be set. There are ways to reduce those costs, court costs, which of course you're very much aware of. But the fact of the matter is you can ask the attorney during that period, how do you charge for probate? Do you charge as a percentage? Do you charge by the hour? Do you separate hourly charges in terms of the attorney time versus a paralegal time? Those are things that truly should be negotiated at that time, because if you don't like the answer of the attorney, then you can look around for another attorney or CPA to administer the estate. You have to understand that this is an area where many law firms, many CPA firms make a lot of money because people don't negotiate. And guess when the worst time to negotiate is?
Oh yeah, right after a death.
At death.
Yeah.
People are in stress, particularly a surviving spouse is upset, and oftentimes it's just, well, don't worry, Ms. Smith, we'll take care of you, and we'll charge you a reasonable fee that will be approved by the clerk of court. And then they get a zinger of a fee of $25,000 or $30,000, and it's like, whoa, how'd this happen? And it was because you didn't negotiate it up front. And like I said, do it at the time you actually talk to your attorney and sign your documents.
The thing is, and I'll advocate for my clients, so many of them feel uncomfortable with trying to negotiate with an attorney. They feel as though it's like it may be the one thing that's worse than trying to negotiate with the car salesman. It's just nobody wants to do it.
You don't have to negotiate. You can compare. Most law firms have ways that they normally handle probate, but there's a difference. Every law firm is different. The hourly charges will be different from one firm to another. Some will have minimum fees, and others will charge a percentage. There are many, many attorneys out who charge 5%, which the statute allows, and that's when folks get these large bills that are totally unexpected when that happens.
Well, of course, the other thing is that, because I warn clients about this all the time, I live in North Carolina, but I've got a property in Myrtle Beach, South Carolina, and I've got another property someplace else. I got a property in Pennsylvania, got a property in Arizona.
Well, that's one of the times, one of the key times when a family should consider trust planning, because a trust will avoid probate and trust or an estate administration, not only in one state, but 2 or 3 states.
Right.
And if you own property in other states, typically a trust is going to be a far less expensive way to handle your estate at death.
All right. So let's wrap this up. I guess the money secret is to get good advice. Haven't we been saying this all along?
Well, it is. It is. I mean, but with estate administration, oftentimes a good family member can do it on their own, but not always. Oftentimes they need a backup. They need a law firm or a CPA firm that handles trust and estate administration. And even if you have a trust, you have to have trust administration. It's not as expensive, it's not as time consuming, it's not as burdensome, but you still have to do it.
Okay, well, we'll be right back and wrap it up. Stay tuned. I guess the money secret here, I was saying right before the break, is it's really about knowing what your options are and getting good counsel and good advice. And so
and negotiating fees, or at least comparing fees at the time that you sign your documents, not at death.
Right. So anyway, well, listen, thank you for watching. I'm Mike Tove of AIN Services. We do financial planning. We can be reached at 800-363-2296, or check us out on the web at www.ain-services.com.
And I'm Bill Alexander of W.G. Alexander & Associates. We are attorneys who focus on estate planning, elder law, and asset protection. And I would invite you to join me each Saturday morning at 11 o'clock on WPTF 680 AM for Asset Protection Today.
Thanks for watching.